So one of the things that I wanted to just remind everyone on the commission is to try and keep our remarks as centered on our work here as possible, and recognizing that all of the commissioners that put forward proposals, as well as members of the public and other elected officials, have put a lot of time and energy into creating proposals that are important to them. And so really making sure that we are not disparaging other proposals. If you don't agree with them, that's completely understandable. That's why we're here, is to have discussion. But to just keep us centered in our work, and also just try we are being as judicious with our amount of time we're spending on discussion, just to make sure that we are able to actually get through our whole agenda. There are folks who wait in order to hear our discussion on if they're waiting for several never get to it. That's not really helping the public feel like they have a good sense of what the work is that we're doing. So please just try and remember to keep your comments as succinct as possible. All right, another piece I wanted to share is that if you are a commissioner who has picked up a public proposal, you really need to get those moving. So please make sure to work with Vice Chair Lentz and with our code advisor and everyone to make sure that we're getting those processed, because we will run out of time in order to get them moved through. So please, if you are a commissioner sponsoring a public proposal, let's get those going. And then I just wanted to clarify that at the last meeting, I called special meetings for June 3rd, 10th, 17th, and 30th. And I believe I did say that's all of the Wednesdays of the month, which is incorrect. We are not going to be meeting on the 24th because we don't have any DPAs who are available. So just wanted to clarify that it is what I stated, which is the 3rd, 10th, 17th, and 30th, which is a Tuesday. But I did believe kind of in the discussion we got to say every Wednesday, and that's a bit inaccurate. So I just wanted to clear that up. All right, that is it for my updates. Are there any legal updates that we have?
Chair, Vice Chair, do you want me to speak to this time?
I heard that we can't hear you particularly well, but we would, if you have a legal update to share with us, absolutely.
I will try to, can you hear me a little bit better now?
Yes, thank you.
Okay, so there was a hearing today that it was relevant to the charter in Superior Court. There was a candidate who filed during candidate filing. He filed for Council District 7, and the charter requires candidates for council to be both registered vote, to have been both registered to vote and a resident of the district for at least a year prior to candidate filing. One of the candidates did not meet the voter registration requirement, and so his candidacy was rejected by the county auditor's office. And so then a lawsuit was filed last Friday, and, or excuse me, a week ago Friday. And there was briefing last week and then a hearing today. And the upshot is that the court agreed that the charter could add qualifications for office, but determined or concluded that requiring candidates to be both residents for a year and registered voters for a year violated the U.S. Constitution, Equal Protection Clause, because filing for office is a fundamental right, and requiring both does not meet the compelling government interest. So it was a bit of a surprise. Essentially, the court upheld the authority of the charter to create county offices and set specific qualifications, but not the additional year of voter registration. There had already been a case that had upheld a year of residence requirement we did not know any cases that had addressed a year of voter registration. I do wonder if the phrasing of the charter, and this is 4.30, it does differentiate the two, residency and voter registration, even though obviously residency is a element of voter registration. You have to be a resident in order to be registered in that location. So, but listening to both of them may give the impression it's adding qualifications one after the other. So, as a result, the candidate will be going on the ballot for the primary, and we might discuss this more when there's another proposal that is in the mix that addresses, I believe, 5 years of residency for county office holders. So we might discuss this a little bit more in the coming weeks. But I just want to give that update since it does pertain to, we essentially had to go to court to defend the charter.
Thank you, Mr. Gaylord. I see Commissioner Murphy and Commissioner Fletcher. Did you have questions for Mr. Gaylord? Wonderful.
Thank you, Madam Chair. Holly Roby, District 3. I am curious about the public comment today, and I'm asking legal to research the RCW that was given by Emily with regards to the executive session that was called prior to our being sworn in with oath of office, and whether she has a claim. She said that I don't know what the ramifications are, but I would like legal to look into that for us.
Thank you. And then Commissioner Fletcher?
Thank you, Madam Chair, Commissioner Fletcher, District 5. Could legal please provide cause number for the case that was heard today at Pierce County Superior Court? If that's something they can provide right now. If not, later would be great.
I can email in a moment.
Thank you.
Thank you. Any additional questions for our Commissioner? Did you have? All right. So that concludes our updates section of our agenda.
I'm sure.
Yes.
I can already get that.
Oh, sorry. I'm not sure where you are on the screen, but Commissioner Lee.
Okay. Where I'm at is important, but okay. To the comment about being sworn in, I just want to make sure the record is straight. If we can get maybe a TikTok or a timeline, because we all were sworn in before that happened. So I just want to make sure that we can get that we pull the official record about the timeline of events, because we all got sworn in. There's a lot of people there taking pictures, and making sure that that was everybody got their Instagram ready to post being sworn in before we went into that executive session. Make sure the record is straight, and we do have that on. Thank you.
Thank you. Any additional comments or questions? Seeing none, next on our agenda is number 8, amendment proposals. So first up tonight is actually going directly back to where we ended our meeting last week, because we were in mid-motion at that point in time. And Marcia Lentz is going to address that.
Just procedurally, it got a little convoluted, so we tried to put a document in everyone's packet that will reorient us. And that's on page 44 of the packet. And just to go back to set the stage, we had began second reading of C40. It was amended in the packets. I highlighted in yellow the amendment that already passed. So the yellow highlighted deletion is to show the tracking of this proposal, but it's no longer part of the proposal because that amendment passed. Where we left off is shown in green highlight, which was the second amendment that has been proposed that we we are currently debating.
Waiting for patient for Shannon's. Oh, did you have words?
Oh, no, I'm just looking at this, I'm trying to make sure that's right. Yeah, oh, sorry, I guess the green highlight didn't show up on the second one, but what's being debated is proposed on page 47, it's shown in strike through. That's where we left off. The current proposal is to also strike that section. We had a motion and a second to begin debate on that amendment to the amended proposal.
Wonderful, thank you. So that's where we're picking things up. Discussion on the amendment to the amended proposal. Commissioner O'Leary, do you have?
Just a question for clarification, please.
Sure.
So, Martha, is there only one green section in this? You mentioned that something didn't show up.
Oh, yeah, no, the second green didn't show up on page 45 of the packet. I highlighted in green the section that we were going to continue debate on. That's just in the rationale, or in the brief summary.
Okay.
But on page 47, I guess the highlighting did not pick up. So I'm sorry about that. But it does show on the first full paragraph on page 47 in the packet, it shows section 5 with strike through beginning with or the filing of a gross misdemeanor charge under 9A. All of that strike through is what Commissioner Roby proposed and was seconded, and which we are debating, and which if that amendment passes, that too will be deleted from this proposal.
Thank you.
Commissioner Kendall?
Yeah, is it appropriate to speak to that amendment at this time?
It is perfectly appropriate. Go for it.
Yeah, I just wanted, as I was thinking about it from last week, I mean, in the political climate, I know we'd all like to think that Pierce County and our prosecutorial staff and everybody in the office is above that level of political prosecution. I just am concerned about language that would be in the charter for the next 10 years when there are new prosecutors and new elected officials. To me, the filing of a charge is inadequate to create a vacancy. So that's why I am in favor of this amendment to the amendment. Thank you.
Commissioner Roby?
Thank you, Madam Chair. Commissioner Roby, disagree. I am speaking in favor of this amendment as well. I do not believe that the filing of gross misdemeanor should be reason for suspension, innocent or proven guilty, and I am concerned that it will be used to keep someone out of office. And so I did propose to strike this language from the amendment, from the proposed amendment.
Commissioner Consuelo?
Thank you, Madam Chair. I just want to remind the public that this does not pertain to like a personal filing against an elected official. This would be coming from an official source, such as a judge or a court, if I'm not mistaken. So if there's grounds for legal plausibility of there being a case, I think that is important. So I am not for this amendment to the amendment.
You two are going to have to do that. I'm going to go with Commissioner Gannon.
Thank you, Madam Chair. Commissioner Gannon, District 4. I wanted to speak against this amendment. I have actually considered proposing additional gross misdemeanors to add to this because I think there's some gross misdemeanors where we really would be concerned as citizens that there was an indictment for those with the people representing us. However, I want to remind people that the indictment for a felony being filed is already in the charter. So I, of course, am in agreement with innocent until proven guilty, but officials are already suspended with pay for felonies. So this is simply adding a few additional gross misdemeanors that are related to official conduct in county office that I think are significant enough to warrant us saying someone else should be acting in that role until that incident is clarified. Thank you.
Judge Jones?
I just wanted to clarify that the proposal that we're talking about here relates only to suspension from office. There have been some comments that it should remove someone from office. Even if this amendment is defeated and this remains in, following up on what Commissioner Yin was stating, it's the charging that triggers a suspension. And under the current language, if a suspension occurs for being charged with a felony, and that felony is ultimately results in a conviction, our current charter states that a person is removed from office. It says right in the section that we're looking at, such suspension continues until conviction, acquittal, or dismissal, and shall be removed from office upon being convicted thereof. So it's already in the charter. It takes both a charge and a conviction to actually be removed.
Commissioner Surratt?
Thank you, Madam Chair. Commissioner Surratt, District 5. I'm going to be speaking against this amendment. I do want to be very clear on a few items right off the bat. First, this does not remove an official based off an accusation. A criminal complaint or charge or indictment or filing of information would all take place after a law enforcement investigation has been completed and a prosecutor will make a charging determination. What my proposal actually does do is, for specific certain gross misdemeanors related to official misconduct and further related to county official misconduct, that there is a temporary suspension of that official's duties until that charge is resolved, just like felonies. Felonies, once charged against a sitting elected county official, already results with a suspension with pay. Again, not every gross misdemeanor will qualify. This is very narrowly tailored. And I would offer to everyone here on this commission that the public expects a higher level of accountability when it comes to abuse of public office. There have been concerns, and I sympathize with them, I think they're very serious, but concerns related to political and fake charges. But that is beyond the scope of this charter. And the answer to that potential abuse is due process and the courts. It's not to avoid very basic accountability standards which are proposed here in C40. The charter should not ignore very serious official misconduct just because it was not classified as a felony. Things like coercion, using an official responsibility, lying, misappropriating funds, making false statements, changing records in violation of the law. These are very serious official misconduct offenses, and I think they warrant a suspension with pay while those charges are being adjudicated. There's also a strange contradiction here. It's being said that we cannot accept accountability standards, that someone may abuse the charging process, but our entire justice system already depends on public officials following the law and acting within their legal responsibility, within the legal authority, excuse me. So, unfortunately, my proposal cannot redesign the entire justice system, and it does not propose to do so. But I think these are very reasonable safeguards to protect the public from abuse of office, from fraudsters and charlatans who hold an office. And I would encourage others to also reject this amendment. Thank you.
And first, if you can please note that Commissioner Randall Kelly is here and runs about 5 minutes. All right, Commissioner Fletcher?
Commissioner Fletcher, District 5. Thank you, Madam Chair. I'll speak in support of this amendment to this proposal. Gross misdemeanor and felony are different things. They have different names. They have different processes associated with these types of charges. And it's correct. The charter as written does permit indictment or information of a felony to begin the suspension period of an official. However, if we look at RSW 42, which is cited in the proposal that, for the purposes of this amendment, would be removed, RSW 42 makes very vague and broad statements as to what constitutes a gross misdemeanor. For example, RSW 42.20.100, failure of duty by a public officer, a misdemeanor. Whenever any duty is enjoined by law upon any public officer or any other person holding any public trust or employment, their willful neglect to perform such duty, shall be a misdemeanor, end quote. This is so vague, I would, with all power within me, want to not allow such a process to be incorporated into our charter, where vague charges of gross misdemeanor and sideline an elected official for a supposedly unknown willful neglect to perform a duty. Duty is undefined. Whenever any duty, I mean, this is something that I don't think would be good for the county, would be good for law and order in our county. Therefore, my position is to keep accountability, but at a level that encourages public trust in our institution, to allow law and order to continue, as well as uphold this principle of innocent until proven guilty. And I do not want to opine on the likelihood or the probability of such misconduct occurring. However, the door is open with this proposal as written. The amendment to this proposal closes that door on any possibility of a nefarious charge of a gross misdemeanor under Title 9A or Title 42. So I will speak in support of this amendment. I would even add additional amendments to this to make it even more clear as to the purpose of this amendment and proposal. Because I do think overall the proposal has good intentions. It is to hold public officials accountable. And I think that's inherently a good thing. However, filing of a gross misdemeanor per the statutes that are cited in this proposal are too low a bar for me to allow elected officials to be suspended and prevent them from doing their duty, which is ultimately an abrogation of the rights of the folks who elected this official to perform their duties. So, in conclusion, I will be supporting this amendment, and I would encourage you all to read the statutes and see what would possibly constitute a gross misdemeanor, and to give pause as to what types of offenses we should hold our public officials accountable to when they were elected by majority vote in the county. Thank you.
Commissioner Will?
Commissioner Rohr, District 6, thank you for your good comment, Commissioner Fletcher. And I would agree, I am going to be supporting this amendment. I do think we need to take official misconduct seriously by our elected officials. At the same time, we need to be careful about what we place into a charter. This proposal adds a new charter level disciplinary process. This proposal adds a new charter level disciplinary process. It would allow the elected official to be suspended with pay when certain gross misdemeanor charges are filed before there has been a conviction or final legit legal determination. It would also create a new legal trigger if that official is later convicted. So that is a significant change. State law already provides laws and legal processes that apply consistently across Washington state, including criminal laws, ethic requirements, recall provisions, court processes, and voter accountability.
Thank you. Sorry, my computer's dying. Commissioner Randall Kelly, or sorry, Commissioner Lonsky, and then Commissioner Randall Kelly.
Thank you, Madam Chair. Commissioner Fletcher, thank you so much for your input on that. I'm in agreement in what you brought forward. I think a little bit more clarity and a little bit more input into this proposal will hopefully clear up the area in regards to that. My concern though is just making sure that we're not, it just, and the same thing Commissioner Wall brought up, that we just want to be careful of the language that we're going to put in there to identify what we consider as that. There, but I really believe, Commissioner Fletcher, you brought up a good point. If we can bring some more in there, not to make it longer, but bring more clarity to it, so that we have a better understanding of how this is going to work. So, yeah, I think that's where my concern is, how it's going to be implemented for how it's going to be forward.
Commissioner Randall Kelly.
Hi, everybody. Commissioner Randall Kelly, District 4, posting online, so I can't be there. I first just want to say that I'm going to be opposed to this amendment. And I think that I find it interesting some of the reasons people are getting opposition to that rather than supporting the amendment. I think it is possible for people of all different political persuasions to hijack political processes and to hijack structures in order to exact specific political agendas. It's clearly happening at all levels of government in the United States right now. I also think that having clarity that we don't want people committing crime in office, in their duties in office, and going against those foreign duties isn't a problem, and isn't, inherently, inevitably more subject to hijack and abuse than any other type of structure that people's own political agendas utilize. I think that the way it's being articulated in the original amendment is clear. Gross misdemeanor is clear. There's clear definitions of the statute, and it's not uncommon for folks that have been accused of crime and appointed or elected positions places to be put on suspension. And I would remind everyone here that it happens with police all the time. Are put on suspension when they're accused of those things, and that is a thing that I think some folks in this room that wouldn't want that to happen with politicians or even client for the police. So I just think we should be, clear about the standard we're setting. I think that we should be able to hold our elected officials to this type of accountability, and I think the likelihood that somehow it's going to cause, a sudden flood of people getting prosecutors to file gross misdemeanor complaints against the political enemies is negligent to non-existent. So I'll be opposing the amendment, and I support the underlying amendment. Thank you.
Commissioner Lewis.
Commissioner Lewis, District 3. I've got a couple questions for the proposal here, the amendment, sorry. I'll be speaking in favor of the amendments only because I have a little bit of issue with some definitions being utilized in this proposal, the original proposal, which we'll get to after this. But in the current proposal being structured, I guess one of the questions I have is, are there currently any elected officials that would be cited under the triggering of the use of some of these words in the actual amendment?
So unfortunately, we're not at the question part, it's more the discussion, so I don't know if that is information we can, is the proposer, it's actually the body's proposal at this point, so unless Commissioner Murphy would like to have something about the amendment that you are asking about.
Fair enough. That would be more reserved for the amendments. Okay, so on the, so one of the biggest issues that I personally have with this is a definition that's utilized inside of the green highlight here, excuse me, and it is added grounds for suspension in office in addition to a felony charge with filing a criminal charge, gross misdemeanor involving official conduct. That word right there, official conduct. For the fact that the legal definition in Washington State of official misconduct is under definition B, he or she intentionally refrains from performing a duty proposed upon him or her by law. And I see that being a very slippery slope, especially for one of our particular individuals in office who is stuck between carrying out conduct, if you will, between the state constitution and the federal constitution, and I feel that this could be politically labeled and misused in the wrong way for political gains, so I will be in favor of this this proposal for deleting those terminologies and words.
Commissioner Herrera. Thank you, Commissioner Herrera, District 2. I'm speaking in favor of this amendment. I'm a firm believer in innocent until proven guilty, and we could potentially be in adjudication for months on end. What happens in that case? So it's a little bit of a government overreach to be in that position. So I will be speaking voting in favor of this amendment, and that's it. Thank you. All right, then we'll go back to Commissioner Murphy to close us out.
Thank you, Madam Chair. I just wanted to clarify that it is true that it doesn't create a vacancy, but it does suspend the person and keeps them from being able to do their responsibilities as they were elected by the voters to do. So it should be a pretty high bar, and a felony is a high bar. And so I still am in favor of this. We do have ethics laws, and when someone takes office, they vote to uphold the laws of our state. They vote to uphold the state constitution and the U.S. Constitution. So to say that somehow by listing this additional requirement, it's going to hold our elected officials more accountable, they're already accountable. So why are we adding this lower bar to suspend someone when it could be used for political gain? And as far as the ethics go, they can be considered gross misdemeanors. And we just had a governor who was the first governor to be actually admit to violating ethics laws. He received a $4,000 penalty, and $2,000 of it was suspended. And it was for use of state resources for private benefit and special privileges, and that's our governor. So, and he certainly wasn't suspended from office. So I think to have this at a local level where there is potential for abuse is inappropriate for our charter. Let the legislature, let the courts work that out.
All right, that concludes discussion on this amendment to the amended proposal. So we'll now take a vote on just on the amended portion of this discussion. Are we all clear on what we're voting on? All right, so all in favor of adopting the amended language to this proposal?
Sorry, point of order. Was there a motion made for this amendment?
So yes, in our prior meeting.
Is that still active then? I'm trying to figure that out.
I was acting as if that was still active since that's when we closed out the meeting. But we could redo a motion right now if that would be helpful for that.
It's active.
Okay. Commissioner Layton, did you have something to?
Yeah, I mean, let's do some logic around it. As Robert told us, we ended the meeting and it should pick up where we left off. There was an active motion on the floor. This is the second time we've done this, and so we pick up where we're going, where we're from.
Okay, because I just wanted to.
Yeah. Bonnie agrees that we are good to be voting at this point, that we're picking up where we left off. Hearing no objection. All right, so all in favor. Commissioner Layton, I'm sorry, I couldn't hear that. What was that?
I request a roll call vote on this amendment.
All right, so we have a request for a roll call vote. So, clerk, can you please call the roll?
George Consuelo,
Nay.
Mason Fletcher,
Yes.
Kate Ginn,
Nay.
Sharon Bennett,
Yes.
Caleb Highland. Caleb Highland.
Yes.
Elizabeth Herrera.
Yes.
Billy Joe Hetherington.
Yes.
Jake Hunter.
No.
Martha Lance. Yes. Justin Layton.
No.
Brenda Likens.
No.
Brenda Molesky.
Yes.
Jerome O'Leary.
Yes.
Holly Roby.
Yes.
Sujata Moore.
Yes.
Devin Rydell Kelly.
Nay.
Troy Surratt.
No.
Jennifer Reed Strickling.
No.
Judson Lewis.
Yes.
Kelsey Mayer.
Aye.
I have 12 in favor and 8 opposed.
So that motion passes. So now we are back to the proposed amendment as, the proposal as amended. All right, so that, we're still in a motion for that original proposal as amended. So that's what we're back to. Vice Chair Lentz.
So, moving back to the proposal as is now amended, I do want to clarify why I voted yes on removing the gross misdemeanor charges as a trigger for suspension. The reason is because I think that this proposal has a lot in it to offer, and if there was a way that we could move it along that spoke to more people, I think that there are lots of things in here that are, as has already been voiced by a couple of people, are good things, they fill some gaps, they provide some clarity, and I'd like to continue to debate this in good faith to move some version of it forward for final consideration. So I wanted to clarify the reason for my vote, and I'm also going to be speaking to some other portions of this as we move forward, if I get called on again.
Commissioner Roby.
Thank you, Madam Chair. I don't know when the appropriate time is, but I would like to make another amendment. I would like to propose another amendment.
Okay, and it's not to any section that's previously been amended.
Not to that sentence.
Okay, great. We just can't, change something back. So just making sure everybody knows that. All right, so what is your motion to amend?
Okay, my next motion to amend is, in that same paragraph, it says, if the executive is suspended, the council shall designate an acting executive. And I want to change it to, if an elected official is suspended, the council shall designate an acting elected official. And delete, if an elected official within the executive branch is suspended, the executive shall designate an acting official for that office.
All right, so I have a motion to amend the proposal as Commissioner Roby shared. Do I have a second? Commissioner Rohr seconds. So discussion on the amendment to the proposal. Commissioner Roby, would you like to speak to your motion?
Yes, thank you, Madam Chair. Holly Roby, District 3. The reason why I'm proposing this is because I believe that this clarifies that this process applies to all elected officials versus just the executive, and the council will be able to designate that elected official. And also, I believe the sentence that needs to be deleted, if an elected official within the executive branch is suspended, the executive shall designate an acting official for that office, is inappropriate. It should be the council. There is a representative from each district of the council, not one person. And so I believe that that more appropriately is the more appropriate route to filling a vacancy of an elected office.
Thank you. So any additional discussion on that amendment? Commissioner Love? Yes. Oh, yeah, we need, there's a point of inquiry.
Yeah, point of inquiry, Commissioner Fletcher, District 5. Thank you, Madam Chair. I must have not been paying attention, and apologies, but could Commissioner Rogie, for the record, restate the language that she wishes to strike? My understanding of it, and please correct me if I'm wrong, is I think the current form is section 5. After thereof, it says if the executive is suspended. I just want to know from what point to what point is this proposed amendment to strike the language in that section?
My amendment starts at, it says if, and it strikes the executive, and it says instead, an elected official. And then it goes to what it currently says, is suspended. The council shall designate an acting elected official and cross out executive, period. Then I'm striking the next sentence. If an elected official within the executive branch is suspended, the executive shall designate an acting official for that office. Striking that sentence, so that it gives the council the authority rather than the executive.
Thank you for that point of information. All right, so next I have Commissioner Willis.
Thank you, Madam Chair. Commissioner Willis, District 3, to that amendment, just for my clarification, do we know if that is a 2/3 majority, simple majority? How the current House office?
I don't have an answer to that question, Commissioner Willis. I don't know if the question is if the council would vote by 2/3 or a simple majority to appoint that position. Commissioner, do you have an answer to that of what? All right, Commissioner Rogie.
Can people please speak into their microphones? It's completely hard to hear. Oh, this one is not working.
No, it's the microphone shuffle. So just if you have a very quick,
Commissioner Ward, District 6, it's a simple majority.
Thank you. All right, so Commissioner Fletcher, was that did you put your card in?
Well, I think I have an amendment to the amendment.
Okay.
Commissioner.
What is your amendment?
My amendment would be, bear with me, section 5, beginning with if the executive. My amendment would strike if the executive until the end of that section ending in general law or charter. My amendment is to remove that. And to make things even more entertaining, I would like to insert additional language into section 6 of this proposal. And, well, it could be section 7, but I think it might be, it's the section that begins elected officials of the executive branch. So it could be section 7, it could be section 6, depending what version we're looking at.
So Commissioner Fletcher, just to clarify, the amendment to the current amendment, you're now increasing the sections. I think we need to keep it. If you can, okay, great. Thank you. As an instant, if it speaks the same concept.
Right.
Okay.
So, in section 6, beginning with elected officials of the executive branch, actually, before I add any language, I'm going to strike additional language into section 6, and this is just for ease of reading and its completeness, where it says, of the elected official or a vacancy as provided in this charter, which is the last few words of the first sentence in that section, I would strike from of the elected official or a vacancy as provided in this charter. Striking that as well. In addition, after that, the next sentence, I would add, and this is additional language, so I believe originally it would say the designation shall. So prior to that, I'm inserting the following language. In the case of a suspension, the council shall designate an acting official who shall serve until the suspension is lifted or the office is filled. In the case of a vacancy, the acting official shall serve until a successor to the office is elected or appointed as required by general law or charter. And then, because my amendment does impact the remaining part of that section, this amendment also, what it does is the very last sentence of that section, beginning upon a vacancy, the acting official shall serve until a successor to the office is elected or appointed as required by the general law or charter. That's redundant, and so I would strike that last sentence. Upon a vacancy, the acting official shall serve until a successor to the office, ... or charter. My amendment is striking that as well. So, to recap for the folks at home and to the audience here, my amendment, in short, removes the last 3 sentences, or 4 sentences of section 5, or the section beginning with an elected official shall. And then my amendment, in addition, touches on the last section, beginning with elected officials of the executive branch. It removes language, quote, of the elected official or a vacancy as provided in this charter. It also removes the final sentence of that section, beginning upon a vacancy and ending with general law or charter. And finally, it adds an additional sentence to say, in the case of a suspension, the council shall designate an acting official who shall serve until the suspension is lifted or the office is filled. In the case of a vacancy, the acting official shall serve until a successor to the office is elected or appointed as required by general law or charter. Thank you.
All right, so that is Commissioner Fletcher's amendment to the amendment. Do I have a second? Second. All right, so we have a second. So discussion on the amendment to the amendment as Commissioner Fletcher read it. And Commissioner Fletcher, would you like to speak to your amendment?
Chairwoman prepared briefly, yes, I would. So I previously mentioned that this proposal does a lot of good things. There's a lot of positive things about this proposal, and this is why I want to make it the best version that it can be. And I think the additions that I have proposed to my amendment to the amendment, one, it clarifies who has appointment power during a suspension period. by having the council do that, I think it actually supports Commissioner Roby's amendment in a way, and it provides further, not clarity, but it just makes it a little bit cleaner. I hope. And what it also, it removes some necessary redundancies as well. And so here, I think the concern for many people in the county and on this commission is having those elected by the council have a say in who the suspended, who the interim official is during that suspension period. Instead of having the executive appoint just one person in one department, having a group of, for now, 7, deliberate and come to consensus on that official is who will step in during that suspension period. I just think that is a step in the right direction for separation of powers as well as balance. But I don't think it necessarily takes away from the intent of the original proposal, but it does, maybe there's additional work you can do here. I think there is. But that's kind of where I was coming from when I heard Commissioner Roby's proposal for her amendment. I just think that will, one, make it easier for the voting when this does come to a vote. If it gets put on in the hopper and sent to the ballot, I think it will be easier for citizens to understand the purpose and the process, how it's supposed to work out. It'll be easy for them to digest and understand all that, and so that's why I'm talking so long. So thank you.
Thank you. Commissioner Roy? All right, Vice Chair Lentz?
Yeah, I wanted to speak in favor of the amendment to the amendment. I agree with Commissioner Fletcher. I think it honors, in fact, duplicates the intent of Commissioner Roby's amendment, which is that in the event of a suspension from office of an elected official, that the county council appoints somebody to be the placeholder for that position while the suspension is playing out. And by putting it in the next section, section 6, 7, however it ends up being numbered, I think I agree with Commissioner Fletcher that it offers some clarity that section 7 is a new section that when I spoke earlier to that I thought this proposal filled some gaps. That's one of those gaps. That new section would propose that any elected official of the executive branch, so that the executive, the sheriff, the auditor, and the assessor treasurer, and the prosecuting attorney, when elected, those officers are to designate an acting official to serve during their absence or disability. They would have to, under this proposal, file that with the auditor. That person that they designated would take the oath of office. We'd have somebody clear and ready to step in. However, adding the language that Commissioner Fletcher proposed makes clear that that's all true, except for in the case of a suspension, it's different because the council has designated that acting official. It's not the designated backup. It's the council that designates who should be the placeholder during the suspension. And it also clarifies that if the position actually becomes vacant, the acting official, whether it's the acting official appointed by the council because the vacancy is triggered by a suspension that becomes a vacancy, or a different kind of vacancy that's unexpected, like a death in office or something, that we know who's going to step in only until such time to actually hold that office until the true process for filling an actual vacancy occurs. So for those reasons, I'm supporting the amendment to the amendment because I think it makes more sense and clarity to place it in this section, and it acts in accordance with the other good suggestions that are in that part of the proposal.
Commissioner Ginn?
Chair. Commissioner, again, I'd like to motion for a recess that includes receiving this amendment in writing over email.
All right, I have a motion for recess. I think we could try and spend a few minutes to get it written up. I can't think of. I have a motion for recess. Can I get a second? Second. I have a second. All in favor of a 10-minute recess, please say aye. Aye. All opposed, please say nay. Any exceptions? All right, 10-minute recess. Be back at 8:21.